is responsive to the needs and aspirations of the present, and is resilient to cope with the demands of the future. The historical and political developments in India made it inevitable to have a Bill of Rights, or fundamental rights as we call it. Calling the freedom movement. It was made as early as in 1895 in Lokmanya Tilak's Swaraj Bill, repeated by Annie Besant in 1925, the Motilal Nehru Committee in 1928, the Tej Bahadur Sapru Committee in 1945. The incorporation of a Bill of Rights was a feature of the US Constitution, not of the British Parliament. The movement in favor of legally enforceable rights grew after the World War, the Second World War. And when these rights are incorporated into the national law and guaranteed by a written constitution, they become justiciable and enforceable. A written constitution with judicial review is adopted by a country because it refuses to believe in the divine rights of parliaments. René Cassin, one of the principal architects of the Universal Declaration of Human Rights, when he was asked as to why an entrenched Bill of Rights was necessary, he said, because men are not always good. Now, man's capacity for justice and adherence to the rule of law makes democracy possible. But man's inclination to injustice makes democracy necessary. Now, all states, whether democratic, totalitarian, communist, whatever, purport to govern for the welfare of the people. But what distinguishes a democratic state from a totalitarian one is that in a free democratic state, respects certain basic rights or fundamental rights. Now, fundamental in part 3, qualifying the rights means that the rights are basic to or essential for a liberal democracy set up by the Constitution. Their essential character is fortified by limiting legislative power, providing that any transgression of the limitations would render the law void and the aggrieved party can seek redress. Thus, fundamental rights are backed by legal sanction. The objectives of the Constitution as declared in the preamble are guaranteed by various fundamental rights, which are enforceable against the state as defined in Article 12, whose import has been expanded over a period of time. Now, it is important that we have one unique fundamental right, that is Article 32, which Dr. Ambedkar called the heart and soul of the Constitution, which is very unique to the Indian constitutional scheme. That is the right to move the Supreme Court for enforcement of the fundamental rights. So not only the Constitution provides and enumerates fundamental rights, but the enforcement of those fundamental rights, it's itself a guaranteed fundamental right under Article 32. Thus, it is not merely a declaratory Bill of Rights, but a judicially enforceable one. The bulk of the fundamental rights is what is contained in the Universal Declaration of Human Rights and various other international instruments. But it is important to remember at this stage that fundamental rights, basic human rights, are not the gift of any law or the Constitution. The Constitution did not confer these rights on us. These rights are inherent and inalienable in all human beings. The Constitution or bills of rights recognize and guarantee them. They don't confer or gift them. And as Professor Edwin Corwin says, no constitution would be complete if it did not recognize these basic rights in the people. So the fundamental rights are not the gift of any law or the Constitution, They are only recognized and enforced by such instruments as the Bill of Rights. Now, Part 4 of the Constitution contains the directive principles of state policy. This is taken mainly from the Constitution of the Irish Republic, where it is called the Directive Principles of Social Policy, which in turn has been taken from the Constitution of the Republic of Spain. The idea can be traced to the Declaration of Rights of Man in France and the American Declaration of Independence. Now, directive principles are said to be non-justiciable in the sense that violation of any directive principles does not give rise to any enforceable right. The sanction is political, not legal. But they are fundamental in the governance of the country. Article 37 says the state shall apply them in making laws. Now, fundamental in Article 37 means basic or essential. It is used in the normative sense of setting before the state the goals which it should try to reach. Now, both fundamental rights and directive principles are integral part of the Constitution and aim at bringing about a synthesis. The Constitution aims at bringing about a synthesis between these two by giving to the former a pride of place and to the latter a place of permanence. Together, they constitute the true conscience. Together, they form a charter of social and economic democracy in the country. The real importance of directive principles is that they contain positive obligation which the states must enforce. They are not insignificant, and if when fulfilled, will change the pattern of the society. They are also known as fonts juris, sources of law. That is, the state where it makes laws has to keep the directive principles in mind. Now, when we talk of fundamental rights and directive principles, it is equally important that we recognize our duties. This was implicit, but the 42nd Amendment, one of the positive things that the infamous 42nd Amendment did was to introduce Part 5A of Part 4A, the chapter on fundamental duties. It's a code of conduct which the citizens are expected to follow. And it is the duty of every citizen to obey the constitutional mandate. Because it is important that we are aware of our duties, because rights without duties can be meaningless and sometimes even counterproductive. For no right can be absolute. Every right gives rise to a corresponding duty. And even the Universal Declaration of Human Rights in Article 29 states, everyone has duties to the community in which alone the free and full development of its personality is possible. Of course, all rights are subject to reasonable restrictions, because without that, liberty may become license. Now, the rights and values which the Constitution envisages and speaks of are not merely material. One of the most important features of a written constitution with Bill of Rights, judicial review, etc., is limited government. That is the essence of constitutionalism. The history has always been now a movement from a culture of authority to a culture of justification, where power and its exercise is made answerable. Constitutional law symbolizes an intersection of law and politics because every constitutional question concerns allocation and exercise of power and cannot fail to be political in a nobler sense. No branch has unfettered powers, unrestricted by the Constitution. The Constitution has devised a structure of power relationship with checks and balances. It is for the court to uphold constitutional values and enforce constitutional limitations. Now, peace is the fruit of justice. A peaceful and orderly society is all what we look for. Justice is what cements the fabric of a secure society. And the Constitution seeks to secure justice for all. The Constitution speaks of justice, social, economic, and political. Now, equality of opportunity is the soul of social equality and social justice. One cannot hope to enjoy one's rights individually if others are not treated equally. Economic and social inequalities rupture the fabric of civil society. An inclusive society fueled by inclusive growth is imperative. Wealth as a social mission, and it must find expression and fulfillment in human well-being with a sensible balance between advancement of the welfare of the society as a whole and economic growth. Access to justice is extremely important. Now, talking of fundamental rights and directive principles, we cannot but remember that what is fundamental in the governance of the country cannot be less significant than what is fundamental in the life of an individual. The basic object of conferring freedoms on individuals is the ultimate achievement of the ideals set out in the directive principles. If the state fails to create conditions in which the fundamental freedoms can be enjoyed by all, then the freedom of the few will be at the mercy of the many, and then all freedoms may vanish. It is this approach of balancing and harmonizing between parts 3 and 4 that has helped Indian society to forge ahead. The Constitution's greatest gift to the social revolution and democracy has been an open society. The Constitution places the individual at the forefront of its focus, guaranteeing civil and political rights in Part 3 and embodying an aspiration for achieving the social and economic rights in Part 4. In a constitutional democracy, it is right that it is the right to question, to scrutinize, and to dissent that enables an informed citizenry, the people, to scrutinize and rein in the government. The full growth and flowering of the human personality and development of the community can take place far better under conditions of freedom. Development is not merely the process of increasing inanimate objects of convenience. The value of accomplishing such conveniences must depend on how it impacts on life and freedom of the people. Whether people have the freedom to do what they value, what they have reason to value. Development really is expansion of people's freedom. That is the blending of the guarantees in parts 3 and 4 and the objectives in part 4. Now, the distribution of powers between the center and the state is spoken of in part 11. And this is one of the one may say, a very beautiful pattern which has been worked out successfully. Because those are matters of detail where you have various constitutional doctrines to check and evaluate the exercise of power. You have a unified judiciary, unlike in other federations. Now, consensus and accommodation characterize and underpin our constitution. In fact, Dr. Radhakrishnan, in a different context, very meaningfully asked, why talk of this or that? Why not have this and that? I think that really symbolizes the nation's ethos. When we say that we are an indestructible union of states, towards this end, we have provisions like common citizenship. We don't have dual citizenship as in America. We have one domicile. You have the right to move about freely and to reside and settle in any part of the country, to own property, to carry on trade, business, or occupation. Interstate trade and commerce without restrictions is guaranteed. One of the most important constitutional values is the freedom of thought and expression, including dissent. It helps to cultivate a sense of tolerance and is indispensable condition of nearly every other form of freedom. It's the wellspring of civilization, for without liberty of thought and for without liberty of expression, liberty of thought would shrivel. Now, these various provisions seek to remove the barriers amongst different peoples. The survival of law or rule of law and an egalitarian society depends upon habits of consent and compromise, which are attributes of a cultivated political society. It's not only obedience to the written law, but what is very beautifully expressed as obedience to the unenforceable, which really is the hallmark of a truly civilized and mature democracy. Your government has to be responsible and responsive to the people's aspirations. Law must reflect the general will, public opinion, which is evolved through consensus, through informed debates and discussion. For law is not an end in itself. Government is and has to be a potent, omnipresent teacher, as Justice Brandeis said. And as John Stuart Mill pointed out, The first element of good government being the virtue and intelligence of the people composing the community, the important point, the most important point of excellence which any form of government must possess is to promote the intelligence of the people themselves. Now, the right to protest entails the duty to listen to other voices and shun intolerance and rigidity. Now, all these are imperatives in a constitutional democracy. But we cannot forget that at the end of the day, constitution and all laws, those values must be in the minds and hearts of the people. As learned Hand said, liberty is in the minds and hearts of the people. If it is not there, no constitution, no law, no court can do much to save it. If it is there, we need no law, constitution, law, or court to save it. So we cannot forget that in the ultimate analysis, the constitution belongs to us, the people. In fact, at the inaugural address of the Constituent Assembly, 9th December 1946, Dr. Sachidanand Sinha, the provisional chairman of the Constituent Assembly, quoted these very prophetic and memorable words of Joseph Story, a judge of the American Supreme Court and an internationally renowned jurist. This is what he said: "The structure has been erected by architects of consummate skill and fidelity. Its foundations are useful as arrangements. Are useful as well as beautiful. Its arrangements are full of wisdom and order. Its defenses are impregnable from without. It has been reared for immortality. If the work of man may justly aspire to such a title, it may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. Republics are created. These are the words which I commend to you for your consideration by the virtue, public spirit, and intelligence of the citizens. They fall when the wise are banished from the public councils because they dare to be honest, and the profligate are rewarded because they flatter in order to betray them." These are very memorable words of Joseph Story, which Dr. Sachidanand Sinha, in his inaugural address, quoted on 9th December 1946. Now, democracy is always a beckoning goal, not a safe harbor. It is an unremitting endeavor, not a final achievement. And that's why Justice Frankfurter very insightfully said, there is no office as important as that of being a citizen in a democracy. The Constitution has survived for 7 decades in spite of some ups and downs. Undoubtedly, it's a proud and happy achievement by any reckoning. But the Constitution is not just for the passing hour. It is meant to survive and endure for an expanding future and to remain alive when the raucous voices of today are lost in the silence of the centuries and the place knows us no more. For this, it is important and essential that constitutional values and aspirations become internalized in the psyche of the nation. On any very momentous occasion like this, when we are observing the Constitution Day, I believe we can have no better wish for all of us than that the spirit of the Constitution may animate our beings and its light illuminate all our thoughts, words, and deeds. Thank you very much for your patient hearing.
Thank you. Thank you, sir.
Welcome, sir.
Thank you.
Thank you very much, sir.
Thank you. Thank you.
Thank you, sir.
Thank you very much.
Thank you, sir. Thank you very much, sir.
Thank you so much, sir.
If someone wants to ask doubts, they can mute their audio and they can pose the question to the
I
speaker.
raise a question, sir. Sir, DPSP Article 3651, which has been totally violated nowadays. The government promises, the parties, political parties promises their manifesto, they are going to do this, do that, but they don't fill their promises. So it is just like a daylight murder of the democracy.
No. Party manifestos are not enforceable. Of course, politically you're right, but not legally, not as an enforceable thing. There is no legal sanction for what is stated in a manifesto. Political sanction, of course. And political parties are expected to honor their commitment. And the sanction against their non-compliance is political. That is your vote and my vote.
Thank you, sir.
Sir, regarding the Article 32, and the Supreme Court observed under Justice Bobde, trying to discourage individuals from filing petitions under the Article 32 of the Constitution. Can I know behind the reason?
Sorry.
Regarding Article 32, under Article 32,
Yeah.
if our fundamental right fundamental right is violated, we can move to Supreme Court. Am I right?
Yes.
But the
And that
last
itself
week,
is a fundamental. That itself is a fundamental right.
Yeah, but the few days back, Supreme Court headed under Justice Bobde observed it is trying to discourage individuals from filing petitions under Article 32 of the Constitution.
Yes.
The Supreme Court observed that one.
Yes.
What is the reason behind of this observation?
Now, I would think there are two parts to your question. The first part is a statement. The second part is what is the reason behind that? That is something that I would be incapable of answering, because what is passing in someone else's mind, you and I would not know. Whether that observation is justified?
No, sir. Any restriction of fundamental rights, that these fundamental rights only can violate, then only we can move to Supreme Court, or some of the fundamental rights can violate.
Oh, is that what you're asking? Okay, I'll address. Okay. No, what I meant to say is why the Chief Justice said that I can't know the reason. But whether the Chief Justice is justified in saying that, I can definitely comment. And I would unhesitatingly say it is wholly wrong. In fact, I have written on my blog that the Supreme, see, two things now. When it comes to enforcement of a fundamental right, no court, be it the Supreme Court or the High Court, has any discretion. It is the court's obligation. Even without a Bill of Rights or fundamental rights, more than 100 years ago in 1913 in England, in Scott versus Scott, Lord Shaw said that to remit the protection of such rights to the area of discretion is to shift the foundations from rock to sand. If that is so, in England without a written constitution and a Bill of Rights, what do we say in a polity like ours with a written constitution and an entrenched Bill of Rights? Enforcement of fundamental rights is not in the discretion of the court. It is the obligation. Under Article 226, when you move a writ petition for any other purpose, well, it is discretionary. But when a writ petition is moved for enforcement of fundamental rights, even under 226, which itself, of course, is not a fundamental right like under Article 32, even so, when the petition is for enforcement of fundamental rights, it is the court's obligation and not the discretion. In fact, courts exist or are expected to exist as the sentinel on the qui vive for enforcement of fundamental rights. And there is no such thing as this fundamental right and that fundamental right. For violation of this right, you can come. For violation of that right, you cannot come. There is no such classification. Though, of course, Article 21 would definitely be at the topmost, because it's only if you are alive that you can have any rights. Therefore, the right to life and personal liberty would be at the zenith of the constitutional scale of values.
Sir, in this continuity, if that is the opinion of the Chief Justice of Supreme Court, Chief Justice of India, what is the remedy left for an advocate, for a legal expert to help the person whomsoever is approaching him to get his fundamental right restored?
I can only say, of course, that the Chief Justice said it is what is reported. I have not heard it. In the sense I was not present. But such an observation is very saddening and deplorable. But of course, what is the remedy left? As the Chief Justice himself said, you have all the other remedies, including 226, which is not blocked. But what I would say is, well, 226 is available, many others may be available, but which remedy to choose, I would think, is my choice, because the Constitution guarantees that right to the people under Article 32.
And in the same line, Mr. Arnab Goswami was treated in a very different manner. Whether this act of Supreme Court will not leave a sort of confusion in the mind of the citizens that they are being discriminated against, and you have to have it is pure discretion of the Supreme Court about Article 32, which is being practiced nowadays.
All that I would say is, whenever matters concerning liberty, any matter under Article 32 and all the more matters concerning life and liberty are engaged, the court must take it up and dispose it off with the same expedition.
Thanks, sir.
Thank you, sir.
In fact, I have written on this. If you go to my blog, you may find something interesting
Thanks,
or
sir.
useful. Yeah.
Anyone else wants to pose a question?
Sir, one question, sir.
Hi.
Hello? Sir, in Article 329, the election is not entered in court, sir. Or in election said so many problems is arrayed. Which article I use for put the case, sir?
Sorry, what's that?
Sir, election said the courts are not entered, sir. In Article 329, they mentioned. Hello?
I'm not able to follow your question. Sorry.
Your
Please.
question is not clear. Can you post the same in the chat box?
Oh, okay, sir. Okay.
So meanwhile, someone wants to pose a question? Anyone else?
Hello.
Yeah.
Hello, good morning,
Go ahead.
sir. Sir, I have one question that nowadays Supreme Court is allotting the what the cases diary numbers as that. Some cases become very fast to the hearing position, and some cases are not in the position. Waiting after long time they are attending the cases. How it is going on, sir?
I don't know how the registry of the Supreme Court works.
Thank you, sir.
The question on Article 329, I suppose, is electoral matters, where electoral matters, the Constitution itself prohibits interference by the courts for the simple reason that otherwise you will never have an election and its result. So until the elections are over and the results declared, no court interferes. That's perhaps what the question was about. Article 320 not entered in elections. That's the way the question is put, of course, with great respect, does not convey much sense. But I suppose this is what the person who asked the question had in mind. 329 bars interference by courts once the election process begins. And that is for the reason that otherwise there'll be no end. You will never complete an election and never have a result in a government. So whatever electoral problems arise, whatever defects, they are challenged after the elections are over.
Thank you, sir.
One by one.
Excuse me. Sir, I just have a question about this. It's about center-state relationship. Actually, constitution, we can amend the constitution by 3 ways. What if there is no other way, like a special majority and a consent of particular state? Because if the matter is related to a particular state, then that state consent should be there. No, likewise, what is your views on that? And one more question is that citizenship amendment and is coming under simple majority. We can amend the constitution
it's
in
a union subject.
Yeah, it's a union subject. That's okay, but it should be special majority or something like that. What do you think, sir?
I don't think so. The Constitution, its wisdom, has provided that. I think that is all right.
And from 1947, many things have changed. Actually, people are being more educated, and the culture, that social status of the people are changed. So there should be more freedom for the states to work, so that the list, the union state and concurrent list should be reviewed or something like.
No, definitely not. The states are immaterial. As I said, it's an indestructible union of states. All the states can die.
Okay.
The unions must live.
Okay. Okay. No, I just
we are one
wanted.
as India.
Okay. Yeah.
Administrative convenience.
Okay. Thank you, sir.
Good morning, sir.
Yeah.
Thank you very much for your wonderful speech delivered. This is also regarding a question relation between state and center. Recently, the state governments are borrowing fund from abroad without permission from central government.
Mm.
The state is forming a constitutional body like some corporation and issuing a masala bond outside India. As per the Constitution 292 article, whether state government require permission from central government to issue such masala bond outside India, or the state can borrow money outside abroad without permission from central government.
Central government.
Is it any such? Yeah.
I think that's a matter that requires a little closer examination. I wouldn't like to venture to offer you an answer straight away.
Is someone else is there to pose a question? Fine. Thank you very much, sir.
Thank you. Thank you.
Now I call upon my colleague, Ms. Sahana Florence, Assistant Professor, Al-Amin College of Law, for vote of thanks. Over to you, madam.
Thank you, sir. A very good morning to one and all, distinguished guest for today's program, respected principal, ladies and gentlemen. It's my privilege to have been asked to propose vote of thanks on this occasion. I, on behalf of the Al-Amin College of Law and on my own behalf, extend a sincere thanks to our speaker of today's program, Mr.V Sudhish Pai, distinguished jurist and constitutional expert, for gracing this occasion and giving an excellent coverage and enlightening us on the topic, an overview of a constitution, a precious heritage. Thank you very much, sir. I would like to take this opportunity to extend my hearty thanks to Dr. Wasim Khan MI, Principal, Al-Amin College of Law, for his encouragement and support. Thank you, sir. I also extend my thanks to Mrs. Yasmin Tabassum, Vice Principal of Al-Amin College of Law, for all her support in organizing this event. Thank you, ma'am. I take this opportunity to extend my sincere thanks to the organizer of today's program, Mr. Mubarak Khan, Assistant Professor and NSS Officer of Al-Amin College of Law, Bangalore. Thank you very much, sir. Finally, I extend my vote of thanks to all the participants, faculty members, and my dear students for being part of this program. I hope you have enjoyed this session and you have gained most of the knowledge out of it. I thank you once again, all of you. Thank you very much. Have a good day. Thank you so much, sir. Over to you, Mubarak, sir.
Thank you all. Thank you, madam. Thank you, madam. Now we'll wind up this program. Once again, thank you, Sudhish Pai, sir, for joining with us.
Thank you. Welcome. Welcome. My pleasure. Thank you.
Thank you. Thank you all.
Thank you, sir.
Thank you, sir.
Thank you.
Thank you, sir. Thank you, sir. Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you very much.
Nice being with all of you to share some thoughts. Thank you.
Thank you very much, sir. Thank you very much.
Thank you.
Thank you so much for your valuable time, sir. Thank you, sir.
Thanks, sir. Thanks, sir. Thanks a lot.
Thank you, sir, and Jai Bhim.
Hey, na kechua. Naya na bhyan chile. गया देखो यहाँ इसके नीचे छह बाबा.
Thank you, sir.
छोड़ करना को कहीं घुमाने होता नहीं उसे मारने होता नहीं इसके तरफ से बैठ के रखने आता नहीं माँ
रख लेना काम